is about the Fourth Amendment, and we'll be starting the webcast in just a moment. Thank you all for coming.
Good morning, or good afternoon. I'm delighted to welcome you to the West Virginia University College of Law Distinguished Speaker Series. I want to welcome two honored guests today. That is the Honorable Phil Gajot, Circuit Court Judge in Monongalia County, and Marcia Ashdown, our long-serving and really fabulous prosecuting attorney in Monongalia County. Thank you both so much for being here today. Today's program, entitled The Vanishing Fourth Amendment, Irrelevance and Consent, features two national heavy hitters in constitutional law and criminal procedure, our own Professor Gerald Ashdown and Professor John Burkoff from the University of Pittsburgh School of Law. We might call them the Corridor 79 constitutional law heavy hitters. Professor John Burkoff earned his JD at the University of Michigan and his LLM at Harvard. He's a prolific author, teacher, public speaker, lawyer, and expert witness. He's been a member of the University of Pittsburgh faculty since 1976 and served as the Associate Dean of Academic Affairs from 2000 to 2004. He has published 28 books and over 60 articles in the areas of criminal justice and legal ethics. He is also the longtime editor of a monthly newsletter relating to search and seizure issues. Professor Burkoff has been awarded both the Chancellor's Distinguished Public Service Award and the Chancellor's Distinguished Teaching Award by the University of Pittsburgh. Professor Ashdown is an Order of the Coif graduate of the University of Iowa College of Law, graduated in 1972. No editing. No editorial comments. After a brief time, that's not so long ago, is it? After a brief time in practice with the Los Angeles firm of Adams, Duke, and Hazeltine, his alma mater invited him to return to the University of Iowa College of Law to teach for a year, a great honor. He then joined the University of Kentucky law faculty and in 1979 became a member of the law faculty here at the College of Law. He also served as an associate dean from 1984 to 1986, 2 years fewer than John Burkoff. It just appears that Professor Ashdown came to his senses a little more quickly. He was honored with the James H. Buck and June M. Harless Professorship of Law in 2001. He's a prolific scholar with a widely used criminal law textbook and numerous articles on constitutional issues, particularly criminal procedure. Professor Ashdown contributes his expertise to the American Bar Association, to the West Virginia Legislature, serving as the reporter on two important projects on criminal justice standards. His scholarship has been recognized by our faculty in 1998, 2003, and 2007, and awarded the Significant Scholarship Award as a result. He also received the West Virginia Outstanding Teacher Award in 2003. Today, these two experts will provide a perspective on the Fourth Amendment, which protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Justice Sandra Day O'Connor noted the significance of this amendment to the framers when she wrote, quote, "It is a measure of the framers' fear that a passing majority might find it expedient to compromise Fourth Amendment values, that these values were embodied in the Constitution itself." Despite the framers' intent to protect against the erosion of the Fourth Amendment by embodying its protections in the Constitution, Professor Ashdown and Professor Burkoff will today discuss the steady erosion of Fourth Amendment protections. Through constitutional expertise and historical perspective, they will reveal how the Fourth Amendment has become irrelevant because of the United States Supreme Court has said that in much police work now, there is no expectation of privacy to protect. There has been no search or there has been no seizure, and that informed consent of the right to refuse a search is simply not required by the Fourth Amendment. Please join in welcoming our distinguished speakers today.
Thanks, Joyce. John's going to start off talking about consent because it's the area where the police these days gather much of their evidence, and the practices in regard to consent have been, I think, as he'll describe, somewhat stretched and abused. So, John, welcome.
Okay, great. I'll go up there, too. Well, I want to thank you for having me here. In fact, this isn't my first time teaching at WVU. I taught criminal procedure here in the summer of 1977, which I know some of you don't remember all that well. And so it's a treat for me to be invited back here every 34 years. And I look forward to, 2045 when they wheel me in, and hopefully I'll teach your grandchildren. I'm going to talk about, give you a little talk that has to do with consent searches. It sounds like, doesn't it sound like that a consent search, how could there be a problem with a search that's by consent? Okay, I have some problems I want to show you. And what I want to do is really illustrate what the law is first, but then what really happens. And you'll see those are different. So here's the talk. I call this Search Me. Okay, consider this scenario. A police officer, uniformed, armed, deadly serious, think Bob Huggins on steroids. He approaches you and he asks if he can search you. He doesn't tell you why he wants to search you. In fact, he doesn't tell you much of anything at all, except to ask if he can search you, and you respond, as most people do, by the way, okay, go ahead, search me. So he does, and let's say he finds some cocaine. I know that wouldn't happen with you, but just let's say. So what happens then? Simple enough. Assuming the officer didn't have a search warrant or act with probable cause under exigent circumstances, the evidence is admissible against you on the basis of your consent. A classic consensual encounter, the courts sometimes call episodes like this. So is that what it is? Or is that what it was? A classic consensual encounter? Really? Well, in my opinion, it was classic. It's classic in the sense that most courts would conclude that it was a lawful consent search, but whatever a court might conclude after the fact, was a search of this sort really, really and truly consensual? Before I argue that a search like this was likely not consensual, not really consensual, let me paint a backdrop for you by sketching prevailing Fourth Amendment law on the subject of consent searches. This won't take long. There are only 5 basic points, and they are these. First, a search of any sort made by a police officer without a search warrant is presumptively unreasonable under the Fourth Amendment. This principle is sensibly enough called the warrant requirement. Second, a lawful consent to search made by a person who is or whose place or possessions are to be searched is a long-established exception to the warrant requirement. Third, in a seminal 1973 decision, Schneckloth versus Bustamante, Schneckloth, I'm going to talk about it again, the Supreme Court held that when a prosecutor seeks to rely upon consent to justify the lawfulness of a search, he has the burden of proving that the consent was, in fact, freely and voluntarily given. Makes sense, right? So fourth, the touchstone for determining whether consent has been tendered freely and voluntarily is to evaluate it under the totality of the circumstances. And one factor in making that assessment is whether the consenting person was actually informed of his or her right not to consent. But the Schneckloth court told us in 1973, the police don't have to tell you that you have the right to refuse to consent. This is the important point. And fifth and finally, consent has not been given freely and voluntarily if it's been tendered in acquiescence to a law enforcement officer's claim of authority. So, for example, let me in, I've got a warrant, and you let him in, well, that's not a good consent. That's just acquiescing to his claim of authority. So here's the bottom line. A person's consent is a perfectly lawful and constitutional basis for a police officer's search if it has been freely and voluntarily given under the totality of the circumstances, and it's not mere acquiescence to a law enforcement officer's claim of authority. That's the law. Now, back to my hypothetical. So you've got a Bob Huggins clone-type cop. He stops someone and he asks if he can search them. Oh, and one other thing. That person's actually carrying narcotics. Nonetheless, she agrees to be searched. Now, the question is, was that a good consent search? Was it really consensual under the prevailing law? Was the consent offered, Supreme Court's terms, freely and voluntarily under the totality of the circumstances. Now, how hard a question is that really? In my view, it's not very hard. Although most courts will condone it, a search like the one I've described is probably not consensual, not really consensual, not in the sense that the supposed consenting party truly, freely and voluntarily, in the Supreme Court's words, waived her right not to be searched. Look, what you have to do here is forget law school for a second, which you might like, and think about this scenario without using any of the fancy reasoning that you've learned here in this fine institution. Just use instead some of that plain old West Virginia common sense. Now, from a common sense perspective, how much of an idiot would a person carrying a gram of crack cocaine stashed in her underwear, how stupid, how moronic, how imbecilic would such a person have to be to really consent freely and voluntarily to being searched by a cop, knowing full well that it will result in the discovery of the cocaine and her subsequent arrest? As the D.C. Circuit observed more than 50 years ago, in a case involving a purported consent by a person to search his room where he had stashed marijuana, they said, quote, no sane man would actually be willing that police search his room for contraband which is certain to be discovered. Exactly. That's all that I'm saying. But if that's the case, then why would a person say, okay, search me, if he or she was not really consenting? Now, you know the answer to that question, too, don't you? It's a matter of common sense. Forget your law school training. There's a cop standing right smack in front of you, Huggins on steroids, and he's asking you, asking in air quotes, to consent to a search, a police officer, an imposing authority figure, and an agent of the state, and if it's Huggins, a big agent of the state. Do you really think that most people would believe that they actually had the right in that situation not to accede to a request of this sort? If your answer is in the negative, if you believe that most people expect that they do not really have the right to refuse such a request, then your answer squares with what a mountain of psychological research has told us. As Janice Nadler at Northwestern has summarized these findings, empirical studies over the last several decades on the social psychology of compliance, conformity, social influence, and politeness have all converged in a single conclusion. The extent to which people feel free to refuse to comply is extremely limited under situationally induced pressures, like this one. Look, even if a police officer asking someone for consent to search believes that he or she is acting as non-coercively as possible, making a simple request perhaps, it's altogether possible that the person to whom such a request is directed would not perceive such an interaction with a police officer as a request, but rather as a demand. Peter Tiersma of Loyola has made this point, that the true meaning of an utterance can differ drastically from its literal word-for-word interpretation. If A says to B, would you like to go to the movies? B will generally interpret that as a question. But now imagine that B is A's 7-year-old son, and the question is, would you like to wash the dishes? Though still phrased as a question, the utterance is in reality a command. And of course, easy for many of you, you've heard this question, would you like to state the case? Or would you like to tell me what's going on in this case? Really, is that a request or is that a demand? Justice Douglas, dissenting in Schneckloff, made this same point, arguing that under many circumstances a reasonable person might read an officer's may I as the courteous expression of a demand backed by the force of law. In fact, a recent empirical study undertaken by a Harvard law student on hundreds of people in Boston found unsurprisingly that the overwhelming majority indicated they would not feel free to leave when being questioned by a police officer. And this was particularly true of women and people under 25, which probably won't surprise you. As the study concluded, even people who know they have a right to leave a police encounter reported that they would not feel free to do so. But don't get me wrong. Even given all of the psychological research and the linguistic arguments, I will readily concede that there are some people who don't feel coerced when an officer asks to search them. It's likely true, I submit, that a significant number of people who are walking around carrying narcotics on or in their bodies are simply not the sort of people who are cowed by authority figures. Hey, if they were cowed by authority figures, ipso facto, they wouldn't be carrying cocaine around in the first place, right? So I'm also willing to concede that some of these drug-carrying, uncowed souls may honestly believe that they are only being requested, not demanded, to be searched by an officer who has stopped them. And this particular uncoerced cohort would certainly be able to freely and voluntarily consent to a search of their persons, even though it would turn up narcotics. Those are the sort of people that the D.C. Circuit, in the decision I quoted earlier, deemed to be insane. But I, more kindly, will simply refer to them as stupid. Look, there are a lot of just plain stupid people in this country. I'll give you that. I haven't actually seen any of the Jackass movies, for example, but I've heard enough about them and the dangerous stunts that are performed by the self-styled jackasses in them, and I've also heard about the scores of people who stupidly imitate these life-threatening stunts, sometimes with tragic, if unsurprising, results. So on the basis of the Jackass movies alone, I am willing to concede that a significant number of stupid people exist. That stupid population further likely includes a handful of people carrying drugs, particularly in that group probably, and who are so sufficiently stupid that they might actually agree to permit a cop to strip search them without any regard to the inevitable consequences, hey, whatever, dude. So now the fact that these stupid people exist should be viewed as a good thing, at least from a law enforcement perspective. As the New Jersey Supreme Court has made the point, it's consonant with good morals and the Constitution to exploit a criminal's ignorance or stupidity in the detectional process. Whatever, dude. In addition, aside from the jackasses who are res ipsa examples of stupidity, there's another group of drug-carrying individuals who might consent to a police officer's request to search them, despite the all but inevitably grievous consequences. I call this second group the tactical optimists. You know these people. Law schools are chock full of them. These are the people who say to themselves, okay, this cop has just asked me if he can search me. If I say no, then he's going to be even more suspicious and he'll probably search me anyway. But if I say yes, then he won't be suspicious because I'm being so cooperative, and then maybe he won't search me after all because I've made it clear by my consent that I'm above suspicion. You know these people, right? You are these people, right? So to the extent that most or any individuals accede to a search request on the hope and a prayer that their cooperation will cause a police officer to relent and love them instead, let me tell you a little secret about this strategy, and you might want to write this down. It doesn't work. Oh, it's true that the occasional smile on a pretty face might dissuade a police officer from issuing a traffic ticket, or so I've been told. I don't know this from personal experience. But no cop who wants to search someone or something or someplace and who has asked for and been given permission to do it is going to desist simply because he's been given permission to do exactly what he wants to do. Police officers aren't dummies. Effective police work often involves trying to make suspected criminals say and do things that are against their interest. Cops know that. Daniel Williams at Northeastern has argued that the search target's disadvantage of ignorance, fear, and resignation are accepted as vulnerabilities we expect law enforcement to exploit to good effect. Now, as accurate a statement of prevailing practice as this may be, it doesn't reflect what the Supreme Court has said are its expectations. The Schneckcloth Court, going back to that 1973 decision, spent page after page trying to make just the opposite point, namely that there's no reason to believe that the response to a policeman's question is presumptively coerced. But as I've explained, there's actually every reason to believe exactly that. As a result, as Wayne Lefebvre, emeritus at Illinois, has given us the bottom line here, the police understand that courts almost never find consents to be bad, and thus they have increasingly come to rely upon purported consents as the basis upon which wholesale searches are undertaken without probable cause and upon no or minimal suspicion. Now, this is no secret, by the way. Police officers are perfectly open about it. I do some training of police officers. As a Pennsylvania State Police Command officer recently admitted, we definitely tell our officers to try and talk their way into a search. Look, obtaining consent to search makes cops' lives easier. They don't have to bother to go to court and get a warrant. They don't have to try and figure out whether an exception to the warrant requirement exists. A good consent spares the officer a lot of work. Unsurprisingly, then, studies show that over 90% of warrantless police searches are accomplished through the use of the consent exception to the Fourth Amendment. Over 90%, and more than 90% of all searches are warrantless searches. So you're talking about most searches in the United States. So if you combine that percentage with the arguments I've been making, then even controlling for the stupid people and the tactical optimists, most people who are searched when requested by a cop who hasn't made it clear their right to refuse are not really consenting, at least not freely and voluntarily, as the law supposedly, but not really, requires. I am, by the way, far from alone in making this hardly earth-shattering contention. As Craig Bradley at Illinois has graphically made the point, consent searches are the black hole into which Fourth Amendment rights are swallowed up and disappear. And other commentators, like my friend Tracy Macklin at BU, have argued further that consent searches during routine traffic stops often function as tools of racial and ethnic profiling, disproportionately impacting minority drivers. So now, let me backtrack a little bit. The fact that supposed consenters carrying drugs on their bodies might not really be consenting to a search doesn't mean ipso facto that people who haven't stashed dope in their underwear aren't really consenting when they agree to a search. It's not necessarily irrational or stupid for someone who's absolutely nothing to hide to truly accede really freely and voluntarily to a cop's request to search them. Presumably, many, if not most, innocent persons want to cooperate with legitimate and reasonable requests to assist police officers. And pragmatically, it's easy to imagine that lots of innocent people would appreciate a chance to prove their innocence by acceding to such requests and demonstrating that any suspicions a cop might have about them are unfounded. But even assuming that many people who do not have drugs secreted on their bodies might possess rational and civic-minded reasons to agree to be searched, that assumption still doesn't mean that such persons have in fact freely and voluntarily consented. Some fairly obvious reasons exist why someone who has done absolutely nothing wrong and has nothing at all to hide would still not want to be searched. Most significant amongst these reasons is embarrassment. It's an obvious understatement to say that a strip or body cavity search is an embarrassing invasion of a person's expectation of privacy. And depending on the scope, duration, and intrusiveness of the search and the gender, technique, location, and professionalism of the searcher, something far beyond mere embarrassment might result, humiliation perhaps, or even lasting psychological trauma. And the embarrassment or worse that might result isn't limited to such intimate searches. The search of a person's possessions or places also runs the risk of the exposure and handling of perfectly lawful and non-criminal but nonetheless highly private and personal items, like tampons, sexual aids, or prosthetics, for example. Similarly, the discovery by searching strangers of contraceptives or medications or pregnancy tests or adult diapers or inappropriate clothing or viewing material can be extremely embarrassing, to put it mildly. And aside from embarrassment, there's the issue of delay and inconvenience. Who in the world would actually want to wait on the side of the road, detained in the middle of a trip to grandma's house or the mall, while police officers paw through the contents of their car, clothing, or personal belongings? So here's the point. If it's really true that there are lots of people who are being deemed routinely by our courts to have waived an important constitutional right freely and voluntarily, and that finding is clearly untrue as a factual matter, then that's a serious problem. What value is any rule of law if it's totally ignored by the courts in actual application? And that's precisely what happens today. Searches that are not really consensual are being treated by reviewing courts commonly, if not more often than not, as if they were consensual. Now, I'm not arguing that the judges reaching these conclusions are dumb or incompetent. Neither am I arguing that they are conspirators in some far-flung ideological conspiracy that they also believe that President Obama is a Muslim who was born in Kenya. I do contend, however, that many of these judges don't really believe that so-called consent searches of the sorts I've been describing are really consensual, even though that's what they find. So why would judges find such searches to be consensual despite their own disbelief? Well, there are a couple of answers to that question. First, there's the issue of what psychologists call actor-observer bias. Simply put, judges are not doing a very good job after the fact and far removed from the scene of appreciating the actual coercive impact of a police officer's request for consent. As Professor Nadler has explained, accurately predicting what a reasonable person would do and feel under a specific set of complex circumstances using one's intuition alone, as the Supreme Court has tried to do, is nearly impossible. That's because, as a general matter, people tend to grossly overestimate the voluntariness of others' actions. A second explanation for why judges routinely find these searches to be consensual is more disturbing. They're following the lead of the Supreme Court. In the application of prevailing consent doctrine, rather than determining whether such consents have truly been tendered freely and voluntarily as the law supposedly requires. In application, by now you will not be surprised to learn, the Supreme Court has never, ever struck down a purported consent as involuntary. Never. Not once. Some individual justices have conceded that consents could not possibly have existed on the facts before them, but those justices have always been in dissent. Now, all of this said, maybe, just maybe, there is a ray of hope that the application of consent law doctrine may begin to truly reflect the law itself, which is supposed to focus upon the actual voluntariness of questioned consents. The reason for this cautious optimism is that in 2006, the Supreme Court handed down a decision, Georgia versus Randolph, which some of you may have studied, in which it focused upon the actual expectations that ordinary individuals have when they are asked to consent to a search. To be sure, the circumstances in that case were different from those I've been discussing, but the basis for the Randolph Court's conclusion that the search in that case wasn't consensual is arguably still applicable. So defendant Scott Randolph in that case and his wife Janet separated, and she left their home in Georgia to move in with her parents in Canada, taking their son with her. 2 months later, Janet returned, and one morning after her return, she called the police to report that Scott had kidnapped their son. When the police arrived, she also told them, you've seen these marital disputes, that Scott used cocaine. Scott returned home. He explained that he'd taken their son to a neighbor's house because he was concerned Janet might take him out of the country again, and he flatly denied using cocaine. Janet responded to that by renewing her complaints about his use of cocaine, and she added, hey, there's some in the house. The police officer then asked Scott for permission to search the house, which he emphatically refused, no surprise. Then the officer turned to Janet and asked for her consent, and she said, no surprise, okay, great. And she led the officers to Scott's bedroom where they found cocaine. Scott moved to suppress the cocaine as fruits of a warrantless search, unauthorized by his wife's consent over his refusal to consent, and a 5-4 majority of the court, in an opinion authored by former Justice Souter, agreed. Most significantly, in reaching this conclusion, the majority made the point that, quote, the constant element in assessing Fourth Amendment reasonableness in consent cases is the great significance given to widely shared social expectations. Souter concluded that such widely shared social expectations dictated that the objection of an occupant who was present at the scene of a search had to be respected, even though another person with common authority was consenting at the same time. As Souter explained, it's fair to say that a caller standing at the door of shared premises would have no confidence that one occupant's invitation was a sufficiently good reason to enter when a fellow tenant stood there saying, stay out. Without some very good reason, no sensible person would go inside under those conditions. There's no common understanding that one co-tenant generally has a right or authority to prevail over the express wishes of another, whether the issue is the color of the curtains or invitations to outsiders. Now, this was the majority opinion. Some of you have read that whole opinion. You see dissent, people like Scalia. Scalia said something like, hey, if I was invited to an apartment and one person said, come in, and the other said, you can't come in, I'm going in. I was invited in. So the common understanding, again, depends on which justices we're looking at. But 5 said, no, don't go in then. The majority added that the obvious social good, discovery of evidence of crime, that might result from a search pursuant to one co-occupant's consent is an important consideration. But more important, the state's interest in crime control didn't outweigh Scott's constitutional right not to have his privacy invaded by the state without a warrant, without his consent. In short, to the Randolph court, the key determination of the unconstitutionality of the search in that case was the widely shared social expectations that we have about our right to keep police officers acting without a warrant out of our private areas. Similarly, in evaluating consent searches that don't involve co-occupants of premises, after Randolph, a person's consent to search should not be deemed to be freely and voluntarily given to a police officer unless our widely shared social expectations make it evident that the supposed consenting party was in fact, really and truly, not fictively or constructively, voluntarily foregoing his or her constitutional right not to consent. Put another way, after Randolph, we should focus on the widely shared social expectations that ordinary people possess when they're asked by a cop to consent to a search. An inquiry of this sort would have the positive effect of bringing to center stage in the assessment of voluntariness the all-important notion of common sense. Common sense, the reality is that there are thousands, if not tens of thousands of people today who are routinely deemed by our courts to have waived an important constitutional right freely and voluntarily, and that finding is simply a fiction. It's flatly untrue. Such consents are, as I've argued, often inherently and sometimes patently coercive. That is, unless and until the person whose consent is sought is, at the very least, made aware of his or her right to decline the request. Now, the Randolph court in 2006 did not overrule Schneckloff, handed down 33 years earlier. And to the extent that Schneckloff survives, a person asked to consent to a search still does not have to be warned that a right not to consent exists. But The Schneckloth court had also held that voluntariness does not require proof of knowledge of a right to refuse as the sine qua non of an effective consent to search. The question is, does that particular conclusion survive Randolph? Namely, that a person asked to consent to a search doesn't need actual knowledge of his or her right to refuse in order to act voluntarily. And in my view, it does not. Or at least it should not. Today's common sense, our widely shared social expectations about how ordinary reasonable people respond to police requests of this sort have changed. Or more accurately, our knowledge about the nature of such common understandings has changed in light of experience and a substantial body of psychological and empirical research. Today, we, if not yet most judges, recognize the truth of the matter, namely that most people do not expect that they have the right not to defer to a police officer's request to search. Accordingly, it appears to me that our shared social expectations today would be, our common sense tells us that one needs to be made aware of the existence of this constitutional right before he or she can voluntarily surrender it. It's certainly not true, by the way, that assuring that people are aware of their rights means ipso facto that they will assert them. Waivers of Miranda rights are commonplace, for example. People retain their God-given right to make civic-minded or stupid decisions to permit such searches. And rational reasons exist for even the most culpable of us to cooperate with the police despite the risk we run through such cooperation. To the extent, then, that the Randolph court's recasting of Fourth Amendment consent doctrine now obligates the courts to pay heed to our widely shared social expectations about when the government should be able to invade our private spaces, revision of the consent search doctrine to square its theory with its application would be an extremely positive development. But is this an over-optimistic dream? Will this actually happen? And my answer is, search me. Thanks.
Thank you, John. Thank you for all coming today. I noticed Joyce introduced me by my real name, which is Gerald. I've never been called Gerald around here in the 30 years I've been here, I don't think. The only time I ever get called Gerald or ever did get called Gerald was by my dad, and when I was called Gerald, I knew I was in trouble. Nevertheless, that is my given name. That's my actual name, and so that was an appropriate introduction. What I'm going to do is talk a little bit more about the macro application of the Fourth Amendment, the irrelevance part of it that's occurred over the last 30 years or so, mainly during the Rehnquist and now the Roberts Court. I wrote an article actually in the University of Pittsburgh Law Review several years ago, which was called in part Bridging the War on Drugs and the War on Terrorism. And that's what I'm going to try to do here in the time I've got. I'll have to do it quick because there's a lot of stuff to cover. But this first part of what I have to say generally involves the war on drugs. Much of this law that the Supreme Court has decided in the last, since, let's say, 1980, the last 30 years or so, has been directed to the war on drugs, including the consent search material. The Fourth Amendment, as you probably know if you've had criminal procedure, is largely driven by the exclusionary rule. The exclusionary rule is the doctrine that says if evidence is illegally seized, it can't be used in court. The Supreme Court applied that to the states in 1961 in Matt versus Ohio in an opinion written by Justice Clark, and Justice Clark gave two reasons for the rule, one of which was deterrence. The notion was if you take away the evidence, that removes the incentive to violate the Fourth Amendment. The other reason, however, was judicial integrity, the notion that the government shouldn't benefit from violating its own laws by introducing evidence in court. What's happened after MAP and more recently is the court has ignored the judicial integrity aspect or reason behind the exclusionary rule, focusing almost exclusively on the deterrent rationale. And what they've done, they've said, is if the deterrent rationale doesn't apply, then the exclusionary rule doesn't apply. And the best example of that, I suppose, is the case called United States versus Leon, where the court adopted a good faith exception to the exclusionary rule. Essentially what they said in that case is if the cops are acting in good faith, even though the Fourth Amendment was violated, but they're acting in good faith reliance on a search warrant, well, there's nothing to deter. So even though the warrant may be faulty or invalid, we're not going to apply the exclusionary rule to that kind of a situation. They've also focused on that deterrence rationale in a number of other cases where they've simply said, well, the cops aren't thinking about grand juries. They're not thinking about federal habeas corpus. They're not thinking about parole revocation proceedings. They're not thinking about deportation proceedings. And so we're simply not going to apply the rule to all of those kinds of proceedings in those particular occasions because the cops aren't concerned about that. What they're concerned about is the trial and the appeal. They're not concerned about these other peripheral kinds of proceedings, and consequently, deterrence really doesn't work there, so we're simply not going to apply it to grand juries and habeas corpus and probation revocation and parole revocation and civil deportation proceedings, etc. So that's resulted in a number of situations where the rule simply doesn't apply because the court has said there's no deterrent impact or no incremental deterrent impact to really be gained there, and consequently, they just don't apply the rule. Let me say one thing more about deterrence before I go on. There's a case that the court decided in 2006 called Hudson versus Michigan. And it's worth noting because it's got ominous potential. In that case, Scalia wrote, it dealt with violation of a knock and announce rule. The rule is if you're serving a warrant, you've got to knock and give notice of your authority and purpose, unless there's a reasonable justification to avoid that. Well, in that Hudson case, there wasn't. They just simply battered the door down without giving any notice, and the court had to deal with whether they were going to suppress the evidence in that context. They ultimately said no, based on a causation theory. But the other part of the opinion written by Scalia examined this deterrence rationale. He did a cost-benefit analysis. What are the costs of the rule? Of course, that's the loss of evidence. What's the benefits of the rule? That's deterrence. And he made a frontal attack on the deterrent rationale. And gained the votes of 3 other justices. So you've got 4 justices now who are pretty much on record as willing to overrule Mapp versus Ohio and eliminate the exclusionary rule. You lost Kennedy, and Kennedy often would vote with that side of the court. Kennedy didn't join the opinion. Had Kennedy joined the opinion, we wouldn't have an exclusionary rule, so we wouldn't be up here talking about the exclusionary rule at all today. So that's a part of the Fourth Amendment that takes on kind of an ominous importance in terms of the non-application of the rule with a deterrent effect is not being fulfilled. But there is this assumption that it applies at trial. The exclusionary rule does apply at trial and does apply in appeal, even if it doesn't apply in these other peripheral areas. But the court there has found a way to limit the operation of the rule by simply finding that there's no Fourth Amendment violation. And what I call those is the no cases. And I call them the no cases because they're cases where the Supreme Court has said there's no privacy interest to be protected. No search has taken place. Or there's been no seizure. Let me explain those as quickly as I can. In 1967, the court switched the focus of the exclusionary or the Fourth Amendment to privacy. And what the old law really based it on property and whether it had been a trespass, a breaking and entering, that sort of thing. The focus in the Katz case focused instead on whether there was a reasonable expectation of privacy involved. Harlan wrote a concurring opinion in the case making the point that there has to be not only an expectation of privacy, but an objectively reasonable expectation that society is willing to recognize. What's happened since that concurring opinion in the Katz case, first the Berger court and then the Rehnquist court with a vengeance, picked up that objective reasonable expectation of privacy notion to conclude in a lot of contexts that there wasn't any expectation of privacy. And, of course, what that means, if there's no expectation of privacy, then there's no Fourth Amendment protection, i.e. it's irrelevant. Some examples. Conversations that you have with somebody else that are reported back to the police or, more importantly, recorded. No expectation of privacy in those. I'll tell you why in a second. Open fields around your house. No expectation of privacy. Aerial surveillance. No expectation of privacy. Bank records that you turn over to the bank. No expectation of privacy. Congress reversed that one by statute in the Bank Secrecy Act. Most recently, garbage. You have no expectation in garbage you put out for collection. The theory behind all those cases was that, well, you voluntarily turned this over to somebody else, and since you voluntarily turned it over to somebody else, you have lost your privacy expectation in it, and consequently the Fourth Amendment simply doesn't apply because there's no privacy interest there. The most important one of those is the conversations you have with another party. I mean, what this means is, even under federal surveillance law, is that somebody who is cooperating with the police and engaging you in a conversation, or a suspect or a targeted conversation, can freely do that without any suspicion, without any probable cause, certainly without a warrant, based on the notion that this person who you're communicating with is voluntarily disclosing this to you, and therefore you have no expectation of privacy in it, even if the person is wearing a wire. Which is a huge hole in electronic surveillance law. They're called consensuals. You probably have all heard of consensuals. I'm sure you've watched television or movies where somebody's wired up. That's what's going on. It doesn't require any kind of justification under the Fourth Amendment. It's simply irrelevant. The Fourth Amendment doesn't apply to it. Those are the no expectation of privacy cases. There's also a group of cases, at least a couple of situations, where the court has said there's no search. The no search cases really involve a couple of different things. One is electronic beepers placed on an automobile. The theory there is, well, that's not a search because the police could simply follow you around and observe where you go with the naked eye. And so this is just technological enhancement of what they otherwise could do. So no search is actually taking place as long as you're out in the public and don't enter a private dwelling or residence. The other one, which is even more ominous than that one, is the dog sniff. And the Supreme Court has held, in a case called U.S. versus Place, that a dog sniff, the dog sniff who's sniffing for cocaine or marijuana, is not a search. And why is it not a search? Well, because there's no intrusion into the area that's being sniffed, and the only thing the dog is trying to smell or detecting is contraband. So that doesn't result in a search either. Now, what that means, of course, is the police can freely use drug-sniffing dogs as long as they're in a place where they're entitled to be, and that doesn't amount to a search whatsoever. So that's the no search rationale. There's one other one called the no seizure rationale. The Fourth Amendment protects against unreasonable searches and seizures. And the no seizure notion really developed in the drug courier profile cases. That's where agents or officers would walk up to somebody at an airline terminal and based on usually some kind of criteria like they got off the plane first, or they got off the plane last, they paid for their ticket in cash, they were traveling to or from a drug city, and they didn't check any luggage. Well, hell, nobody checks luggage anymore, I mean, as far as you know, but we know because everybody gets on the plane and carry on stuff because they want to pay the $25 to check it. But in those days, that was one of those criteria. Eventually, those cases evolved into a notion that, well, that's not really a seizure when the cops walk up to somebody and ask for identification and maybe their airline ticket and permission to search as well, which, as John indicated, is often quite productive. They took on sort of an odd twist in the working the buses cases. The working the buses cases dealt with officers boarding a bus during a stopover. And what they would do is they'd put one officer at the front of the bus and another officer or two would walk through the bus, or maybe one even go to the back of the bus, and they'd walk through the bus until they found somebody they thought was suspicious. Of course, guns were shown, not drawn, but they had guns, and the suspects could see the guns. And they'd walk through the bus, and they'd see somebody suspicious, and when they did, they would ask for identification, see the bus ticket, and, of course, then ultimately for permission to search. And the question in those cases became, well, is that a seizure? The court originally had said in these airport terminal cases, well, that's not a seizure because a reasonable person would believe they were free to leave. That's questionable, I think. It's like consent to search. And when you're confronted with a cop and asked for identification, do you feel you're really free to leave? And, of course, the court later held if you do try to leave, that's enough suspicion to arrest you anyway. So you got a kind of an odd paradox there. But the thing in those buses cases, the odd thing about it is the argument, of course, there was made, well, nobody who's on a bus on a stopover from one place to another place, and their destination really feels free to get off the bus and leave. Their luggage is on there. They're going from one place to a new destination. And so what the court did there was switch the free to leave inquiry to whether the person would feel free to decline the officer's requests and otherwise terminate the encounter. And so what they held in those cases, the working the bus cases too, originally the airline terminal cases and the bus cases, is that there was no seizure. There was no seizure at all, so the officers didn't need to comply with the Fourth Amendment. There didn't have to be any suspicion to approach somebody and ask for the airline ticket or ask for permission to search. The odd thing about that, and it's never happened, and I've always been curious as to why, I've never run into a case yet, and maybe John knows of one, where they worked the planes. You'd think that that would be the next step, and it's probably not the next step, or never has been the next step, because of the difference in the caliber of person who flies opposed to riding buses, and the airlines probably are unwilling to allow them to do it. But it's sort of odd that it hasn't progressed from the airline terminal to the buses to the actual airplane itself. But in all those cases, the no privacy cases, the no search cases, the no seizure cases, what that means, and this is the point of this, the Fourth Amendment doesn't apply whatsoever. I mean, the Fourth Amendment's irrelevant because there's no privacy involved, there's been no search, or there's been no seizure. That means that the agents or officers don't have to have any justification whatsoever to approach somebody and ask them for identification, maybe a ticket, and of course, ultimately for permission to search. Now, you can ask yourself, like John discussed, when you're approached by an officer and asked for identification, do you really believe you're free to leave or otherwise terminate the encounter? Well, I think we all know the answer to that. The answer is no. You don't feel like you can leave. You're confronted with an officer who is asking questions. You feel like you're obliged to stop and comply. So those are kind of odd cases that really whittle down. What's happened here is the Fourth Amendment's been taken from where it was out here and it whittled down to a much smaller kind of sphere. And, of course, where the Fourth Amendment doesn't apply, the exclusionary rule doesn't apply. So you don't have to worry about the exclusionary rule there because the Fourth Amendment simply is inapplicable. Let me just quickly mention vehicles, and I'll go on to the war on terror real quickly. Vehicles have always been a really special category because the court has always allowed pretty much open season on vehicles. The notion was they were mobile. And since they were mobile, they might get away from the cops, and so they needed to search them right away without a warrant. So the notion was if you had probable cause, you could always search a vehicle without a warrant, and that's still the law. The theory has switched a little bit because in some of these cases, the automobile or the vehicle was immobilized, wasn't going anywhere. So what the court did, it switched to a diminished expectation of privacy theory. That is to say, well, the car is mobile and it travels around in public. You can see inside it. It's subject to heavy regulation by the state. And consequently, you have a diminished expectation of privacy in that car. And consequently, you don't need a warrant, even though there's plenty of time to get one to search it. That's pretty much always been the law. But the interesting thing that's happened in the last 20 or 30 years or so, 25 years, is this battery of decisions that the court has decided which permit really very permissive investigatory practices in the case of vehicles. And what they say in these cases is essentially this. The cops can stop a car if they've got probable cause to believe that a traffic violation has been committed, even though that's a pretext to do an investigation for something else, to find contraband. Doesn't matter. As long as they've got probable cause to stop the car for some kind of traffic violation, even though the stop was a pretext to search for drugs, that's okay. That pretext doesn't violate the Fourth Amendment. So what that means is this. It means that, and as one of the Justice O'Connor, I think, commented in one of these cases, all a cop has to do, if he wants to stop a car, is follow it for 2 or 3, 4 blocks, 6 blocks, and everybody will violate some traffic law in 6 blocks, so you got a justification to stop. Well, what happens when you stop the car? Well, what happens when you stop the car is what John was talking about. They ask for consent to search, and in most cases, consent is granted. What if consent isn't granted? Well, if consent isn't granted, the court has given the police the authority to arrest the driver for the traffic violation, even though it's a minor traffic infraction. Failing to wear a seatbelt in Texas is an example. When you arrest the driver for violation of the traffic ordinance, you can take them into custody, if state law allows it, do a full body search of the person. If they're anywhere close to the vehicle, search the entire interior of the vehicle, including any containers found inside. And if that's not enough, then once the driver is taken away, you can impound the car and take it to the police lot and inventory it. Connor made this point in one of these cases, Atwater versus City of Lago Vista, how much discretion the police have in that context. And if you don't believe that's happening, let me give you a little example of a comment that one of the Fifth Circuit judges made in a case decided back in the 90s. He made a comment about a remarkable record that this Utah cop had of turning 250 traffic stops into drug arrests. So it does, in fact, happen. I mean, the other thing that you may be aware of, too, is the court has ultimately validated these DUI checkpoints, without any suspicion or individual suspicion or probable cause. As an aside on that, my dad was a lifelong Republican, and sometime in the early 80s, he got stopped at one of those DUI checkpoints. This was before the court even validated the things. And he came home, and I remember he was furious about being stopped for no reason. He didn't drink, and he wasn't in jeopardy of being arrested. But he came home, and he was really pissed off. And he said, "I'm never voting for another Republican again in my life." Because Reagan was president, I guess, and so he blamed Reagan. It's like voting for Eisenhower because Lincoln won the war. To quote John Prine. Let me just mention quickly, so we're out of time, the war on terror. And as you all know, what I've been talking about was mostly driven by the war on drugs. The war on terror, on the other hand, was produced by September 11th, 2001. And what that did was give us the USA Patriot Act, one of my favorite acronyms, unifying and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. Now, somebody thought hard on that one. But what that did, and this is where people, I think, finally started getting a little bit antsy about their erosion of their Fourth Amendment rights, because it was a little bit more public as to what this new statute allowed the government to do. It allows what you probably heard are sneak and peek search warrants, where you can go in without any notice and leaving any indication that you were ever there. And that applies to domestic criminal investigations, too. It allows a nationwide service of search warrants by any district judge in the country can issue a warrant to search anywhere in the United States and any other district. Formerly, it had to be within the judge's district, at least in the cases of international or domestic terrorism. It expanded the Foreign Intelligence Surveillance Act to cover not only foreign intelligence gathering, but at least some domestic crimes as well. And the Foreign Intelligence Surveillance Act is very lenient in terms of what it allows the government to do in order to get a warrant to conduct surveillance activity. It expanded this notion that when you dial numbers from your phone, those numbers are not given any privacy expectation because you voluntarily disclose those numbers to the phone company. The way the phone company gets those is through what's called a pen register and trap and trace device. But those early cases were talking about phone numbers, and the Patriot Act expanded that, you can guess, to email and internet communication, at least in terms of addresses, not necessarily content. We could talk a little bit about technology today, but that's kind of well beyond the scope of this. But the basic difference now in Fourth Amendment law there is that if it's envelope information, if it's phone numbers or email addresses or internet sites, those are pretty much accessible by the authorities. Whereas if it's content information, there's much more restriction on the ability of agents or officers to get at that. Two other things that the Patriot Act does is provide for the seizure of business records, only on a showing, at least in the cases of terrorism investigations, only on a showing of reasonable grounds to believe that the target is involved in terroristic activities. There's the national security letters, things you probably all heard about, which don't even require a judge. Just a FBI field supervisor can issue one of these things sua sponte, on his own, ex parte, just certifying that the target is the reason for the letter is to acquire foreign intelligence information. And those things were used extensively after September 11, 2001. And, of course, just to add to that, you all know about the Bush administration's extra-legal collection of data and electronic information that occurred, and admittedly occurred between 2002 and 2006. So that's kind of an overview of what's going on. I did it pretty quickly, and I hope that it provided some insight. But that's what's the irrelevance part of it is. It's taken the Fourth Amendment from a very broader stage or stature that it had back in the 60s and reduced it now to a much, much smaller sphere. So thanks for listening to me, and I'm glad you all came. It's a nice audience. So if you have any questions, we probably have some time to take a few.
And actually, let me seize 90 seconds to follow up on what he just said. Just 90 seconds, which it's law professors, 90 seconds, so it could be done a couple minutes. But, there are a number of you, as I mentioned before, who were born after the last time I taught here. And lest you think all this stuff is history, one of the things I'm working on right now is the question of when can the government read your mind? In fact, 15 years ago, I was named to an ABA Blue Ribbon Commission, and we were charged with studying when can the government look at you naked. Oh, said some of the ABA, they're never going to come up with devices like that. Forget it. We met, and we had law professors, defense counsel, prosecutors, judges, some people from some agencies I wasn't allowed to know where they were from or what their names were, and we came up with some rules, and they've all been ignored because we didn't act quickly enough. Before we finished coming up with some rules, they actually came out with the devices. And as you know now, because some of you have been scanned like this, you will be, the case law is developing, held really no longer to have a reasonable expectation of privacy that your body might be viewed by people from TSA. Mind scans, you could laugh about this right now, but they already exist. Two different sorts technologically. The CIA is using them in Iraq and Afghanistan and other of our rendition centers already. The difference with what will happen with mind scans, and right now you have to put electrodes on people's heads, and you can figure out, you can ask them questions, and they're much better than a lie detector in telling you what they're thinking, and you can find out, and we've probably gotten some good tactical information from using these. Now, if you're law enforcement, you don't want to use anything with electrodes. It's no good for you unless it's got a trigger. All the law enforcement people I know, they want someone with a trigger. I can tell you, and just the story of my life, they're going to have things with triggers, which they can aim at your head, and it'll tell them roughly what you're thinking. Maybe big, broad categories as opposed, I want to commit a crime, as opposed to something else. The question will come up in your professional lifetime. Fortunately, we'll be wheeling around by then, of when can the government use that? And frankly, if you use the case law that we have from right now, which is, do you have a reasonable expectation of privacy? Well, you know why dogs can sniff you? Because when you walk around, you've got your scent. You're giving off your scent. So, hey, you stupid. If you're giving off your scent, then the government can pick it up. Well, if the government can pick up thoughts from outside your head, too, with their trigger devices, what do they need to use those devices? A warrant? No. Exigency, consent? No, nothing, because it won't be a search. So these issues are really live. The court has, actually recently, as I mentioned in my case, and there's some other cases, started to focus on them. And from both of our perspectives, that's a really important development. Thanks.
Thank you.
The exodus right now are students that have to go to class. So I want to make sure that everyone understands they're not being rude. For those of you who choose to stay as soon as the major movement is over, there is a microphone actually in the center of the room, and we'll ask you to go to the microphone to pose your question, because that is the only way that we can record it and have it be part of our webcast. So if you do have a question, Professor McLaughlin, it looks like you have one. If you want to go to the microphone in the...
It's Professor Imbow.
I used to argue these cases on the Attorney General's side in Ohio, so
I have a couple First Circuit cases like this. Are there any, this question, are there any remedies against Fourth Amendment violations for innocent people, people who actually don't have cocaine in their underwear and who are strip searched and by a false consent giving? Is there any innocent person? That's who the Fourth Amendment's designed to protect.
I'm sure you're going to have a follow-up to the answer to that question, right? I'm sure you have a follow-up question to the answer to that question.
No, but let me answer that, which is the answer is yes. There are a number of possible remedies, and there have been periods of time where the courts have dealt with this and have said, and of course that was part of MAP, they're not adequate. Now, frankly, those remedies are changing, and actually some of the current majority justices have made that same point. The primary remedy is a civil lawsuit, 1983 action, but the problem with that is they, one, are rarely successful, and two, there are so little damages in most of these cases that lawyers don't want to take them. So, for example, what the police have done, and you're totally innocent and they totally screwed up and everybody agrees with it, and they've strip searched you. Now, you may think that's worth a lot in terms of damages. Oh, that's not so much what the courts think. Seeing you naked out on a public street in a strip search, that's probably worth $3,000. Pittsburgh, maybe $4,000. You don't get much more than that. Now, you're a lawyer and you're working, let's make you work 40% contingency fee. You're not taking that case. And so the only kinds of cases that really are successful against police officers are when there's lots of damages. Some of you who actually go into this business and do this kind of work are going to be kind of perversely hoping that your victim comes to you and they're really hurt. Because if that's the case, now you got a lawsuit, now there's some money in it. But that's not what happens with most cases. Plus, in many of these cases, contrary to what Professor McLaughlin talked about, what you have is not necessarily innocent people, but bad people who also have constitutional rights. Bad person's got drugs on them. Well, they're still not supposed to beat them up. Now, the problem is...
They're in prison.
Well, the problem is when you take that to a jury, that jury's not so keen on bad people for obvious and sensible reasons. So even if their rights are violated, it's very, very hard to vindicate them, and they do have some rights still.
Scalia is right about one thing. I mean, the Attorneys' Fees Act that was passed in 1978 has encouraged lawyers to take 1983 cases, even though there may not be a lot of damages available, because that statute makes attorney's fees available when you win. And so there's much more incentive there now than there used to be to take civil rights cases, even Fourth Amendment violation cases. What Scalia said in that Hudson opinion, he said, well, we don't need this exclusionary rule because we have all these other remedies. We've got the 1983 remedy, and we've got police training and professionalism, and consequently we don't need that exclusionary rule. And, you've got three other people to agree with him.
And it's true. I've actually been an expert witness in about a dozen West Virginia cases, sometimes on the plaintiff side and sometimes on the police side, for whether or not there was Fourth Amendment violations. And there are cases with recoveries.
There are no police review boards that have effective.
Not effective, even though I was the first chair of the one in Pittsburgh, it's not effective.
The the response from the floor was that there are no police review commissions for the most part. Is there another question? And if there is, would you please use the mic? Thank you.
I got two questions. The first is, are there any social science studies or any comparative studies for states or governments that require consent for searches? Do any governments require a notification of consent, a kind of Miranda warning for consent? And the second is, this is kind of tangential, but for a litigator, if you really wanted to prevent police intrusion, say you're a community person, could you move for equitable relief against a specific police department under 1983? Because, that's part of the statute. Would that be a tactic that lawyers could adopt to try to keep specific police departments or specific departments, even in the government, from conducting searches that violate the Fourth Amendment? Or is that somehow not?
To address your last question first, Could you clarify what you mean by equitable relief? What are you trying to enjoin?
Injunctive relief. Just say that, okay, so you sue the Morgantown PD or University PD and say that, we've established under 1983, there's no real damages, but we're looking for injunctive relief. Like that kind of relief.
For future conduct.
Yeah, for future conduct.
You don't even need 1983 for that.
Okay.
Yes, sometimes, it's pretty rare, but sometimes if what you can do is establish a practice, that there's actually been a policy of police officers doing X. I'll give you an example. Every once in a while you'll get a serial killer or a rapist, and obviously everyone's alarmed. And they might have a very generic but not very specific description of, the potential bad guy. And the police go overboard looking for all African-American men who are 6 feet tall and doing things. Actually, that's a real case. And you can go to court and you can get an injunction against the police doing that. But again, you need a pretty significant case. You don't need 1983 at all. And you need, because there's not going to be damages in there, you need somebody who's got some money to actually bring a case like that. Your first question on are there jurisdictions that require warnings? The FBI has always required its agents. Now, some of you may talk to FBI agents and they didn't do this. They were supposed to. The FBI traditionally, for decades, has given you a warning that when they ask you if you want to be searched, they tell you that you have the right. In terms of state jurisdictions, there's starting to be a trend to thinking about it. Connecticut Supreme Court last year split on this. The majority said, no, you still don't have to give a warning. The dissenting judges, actually citing some of the articles I've written on this, said, yes, you should have to give a warning. But so there's some movement, and the movement is, I've got a justice in Connecticut. That's pretty much it. Empirical work, which is a start. Empirical work, there's a lot of empirical work on this, and email me. I'll give you some sites to it, including it was a 3L at Harvard who did a really interesting project, and actually I was a consultant on doing that too, and I just gave a 2-sentence description. He did something that's quite interesting and been published. And he's gone through a lot of the other empirical work that's been done on this too.
Actually, Andrew, the West Virginia legislature passed a statute last year which requires the officers in the state to get a written consent form signed. We looked at it this morning. I don't think it requires...
Written or oral with audio. One terrific development, frankly, and it should be a terrific development from liberal, conservative, Democrat, Republican point of view, is cameras in police cars and microphones on cops. Frankly, most of the time, these are going to protect the cops. In fact, I've been, again, expert in 1983 actions in West Virginia, where what I was done is they showed the video and I said, yes, you can stop them for that. But it works both ways. When they do something wrong, we actually, instead of having his story and her story, we actually have a tape if they haven't destroyed it. And sometimes they're hard to destroy.
Thank you.
I'd like to know whether there has been any successful 1983s filed with regard to the Fourth Amendment violations here in the local level or on the state level.
Sure. There have been some successful ones. It's just hard to win.
Could you give me some citations, some examples of the successful litigation of the Fourth Amendment?
Well, here's the problem, because I can't answer for West Virginia as easily. In Pittsburgh, there are hundreds or thousands of them. The problem is this. The only ones you actually can really find are when they get appealed, because they're trial-level decisions, and if they're appealed, then you get an appellate court record. Frankly, in a law library, you'd find thousands of them. Not hundreds of thousands, but maybe even tens of thousands of successful 1983 actions. They're hard to bring, and one of the things we haven't talked about is the nature of a 1983 action, because, and I'll just say one thing about them. I'll just say two things about them. One is you can't be successful unless you show that the police officer acted in bad faith, because even if a police officer did something wrong, but he or she thought he was doing it right, that's still okay. And two, really, most lawyers who are bringing these actions aren't really going after the police officer. What do police officers own? They have $180 in the bank, maybe, if they're doing well. They got an old car. You don't want a judgment against the cop. You want a judgment against the police department or the municipality. To do that, to get that, you need to show there was a plan or practice that police officer was following, and that sometimes becomes difficult. It's possible, and I'm sure you have successful suits here. We have successful suits all the time in Pittsburgh. In fact, one attorney makes his living, a good living, just doing suits like that. But they don't account for the majority of cases, and frankly, the majority of cases aren't questioned. I mean, we're lawful in any event.
Do we have any examples of a local or statewide attorney that is pursuing 1983 litigation dealing with Fourth Amendment issues? I mean, do you know any off the top of your head?
In this
state or in this region?
You could probably find any number of lawyers that would take those kinds of
See me
cases.
afterwards. I'll give you a Pittsburgh name afterwards.
Thank you. We've actually run out of time for questions. There's a reception in the lobby, and I want to thank you all for coming, and particularly thank our guest, Professor Burkoff, and our own resident Jerry Ashdown.
Thanks for inviting me. That's fun.
I was going to